electronic monitor, which does monitor your skin and your sweat. So it'll detect if there's any amount of alcohol in your system.
Yeah, that's fine.
Plus, if you don't get gasoline or rubbing alcohol or mouthwash or probably cologne near it, because it will go off and give a false positive. I'm going to tell you right now, I don't listen to people's excuses of false positives. If it alerts that there's that it detected alcohol, you will be told you're immediately revoked and you must go sit the rest of the time in jail. No good time, no Huber. All right, thank you. We will go on the record in the matter 26 CT03, State of Wisconsin versus Daniel Capuzzi. The state appears through District Attorney Kevin Schmidt in person. Mr. Capuzzi appears in person without counsel. We're set today in this matter for a status conference. Mr. Capuzzi, can you update me?
So I contacted the attorney from that you given me his information. He's advised me to contact the sheriff's department in Polk County where the accident took place because his customer was the Progressive Insurance or whatever it was, not. So then I contacted them. They told me to contact St. Croix Falls Police Department. I did that. St. Croix Falls Police Department took my statement, got a hold of the gentleman whom was in the accident with the person who bought my truck. And that's where it's been going since then. He was in town Thursday and Friday, but nobody was available to verify it was him for the statement. It's been a lot of phone calls and a lot of tracking people down and I wish I could remember the person's name that I just talked to on Monday, but it's not going well.
So you have to clear up that accident issue before you can even get your license?
Yes. Yeah. However, the insurance company had filed it, and it's $5,000, and we're in the middle of trying to get our house back and stuff from the fire. So it's been.
I know you've had a lot going on.
It's been a really crappy couple months.
Okay, so it sounds to me like it's going to be a significant time before you can get your license.
Yeah, I don't even know this. The final, one of the things that one of the people said to me was to try and pay the $5,000 and just take the guy to court. You know, that drove my truck. Was my truck. I'd sold it to him 3 years prior, but I just don't even know what to do.
It sounds very frustrating. It sounds like it's a lot of work and a lot of hoops that you have to jump through. And to me, it also sounds like it's going to take a lot of time.
Yeah,
and so right now, I mean, you do have the option and the choice to accept the state's offer of plead to the charge for costs. And I'd be willing to waive all costs except for the mandatory $200 if that's what you wish to do. Because this case can't wait for a year.
I can do that. I would do that.
Is that what you want to do?
Yeah, I do. I mean, yes, that's what I want to do.
Okay, and that offer still stands? Mr. Smith?
Yes, Your Honor.
Okay. So, Mr. Capuzzi, how old are you?
48.
38 or 48?
48.
48. And you can read, write, you understand the English language?
Yes, ma'am.
Any drugs, alcohol, or other medications?
No, Your Honor.
Do you understand that you would have the right to have an attorney, and an attorney goes to law school to learn certain things and to learn the law and to learn how to analyze and look at the law, to look to see if you have any defenses or a lack of defenses, to negotiate with the state on your behalf, to make arguments to the court and to the jury? Do you understand those are all advantages to having an attorney?
Yes.
And do you understand that by not having an attorney, you have the disadvantages?
Yes.
And you still wish to represent yourself?
Yes, ma'am.
Do you understand you have the right to a trial? You would have the right to have yourself testify or not to testify and be silent and have your silence not used against you. You would have the right to cross-examine the state's witnesses if you wish, or if you had an attorney. You would have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes,
You understand that here, the state would have to prove on or around December 21st, 2025 in Burnett County, Wisconsin, that you operated a motor vehicle while revoked. And your privileges were revoked pursuant to Wisconsin law, and you did operate that motor vehicle in the county and state during a revocation period or thereafter, and the revocation was a result of an OWI or similar offense.
yes,
You understand that upon conviction, you could be fined not more than $2,500 or imprisoned not more than 1 year in the county jail. Do you understand that?
yes,
Do you understand that there is an offer that has been extended to you and you have accepted where there's a recommendation to the court for costs only? Do you understand I'm not bound to follow that?
yes, ma'am, I do
Said
understand.
differently, I could sentence you to the maximum possible penalty if I thought it was warranted.
Yes, ma'am, I
Do you
understand.
still wish to proceed and enter a guilty plea?
Yes, I do.
Are you admitting here today you in fact did operate a motor vehicle on a highway or roadway of this county and state,
Yes, ma'am.
and that your privileges, your driving privileges were revoked,
Yes, ma'am.
and you knew they were revoked?
Yes, ma'am.
All right. Has anyone made any threats or any promises to you for you to plead guilty today?
No.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes, ma'am.
and voluntarily.
Yes, ma'am.
You have any questions for the court or for Mr. Schmidt before I proceed?
No, I do not.
Then as to count one, operating motor vehicle while revoked, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count one. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
Thank you, Judge. I think the court should do this agreement. Mr. Capuzzi has had a number of OAR or OWLs within the past 5 years. However, the last one was 2025 and the last one before that was 2022. So there is some gap. The problem he's running into is his license got suspended because DOT can suspend your license if there's a damage judgment against you. And they suspended him until 2029. And the only way he can remedy that would be one of two ways. One, coming to an agreement to an installment plan on that the clerk of courts accepts. Or, as is the case in this situation, Mr. Capuzzi indicated he's a victim of some sort of impersonation or false charge. So he's trying to attack the judgment itself, which is much more time consuming, too time consuming for him to get his license through this course of business. And as a result, the court should be lenient and do a fine only. Thank you.
All right, thank you, Mr. Capuzzi. Anything you want to add or say?
No, ma'am.
I understand your situation and all of the things that you are having to live through and work through. It's a lot. And I don't know. Some days I'm sure you're overwhelmed completely.
Every day.
And so I'm very sorry to hear that. You are accepting responsibility. You're pleading guilty to a criminal charge, and you're doing so in a rather quick fashion instead of dragging this out. So I do think that costs are appropriate. What I'm going to do is I'm only going to order the mandatory $200 DNA surcharge. I will waive the rest of the court costs and fees because I know the struggle that you are going through right now. I am going to order that $25 a month you pay.
Okay.
But I can give you until September to make your first payment.
Okay.
It gives you some time to save some money. Or if you can pay it the whole $200 off, if you are able to scrape that money up and then you want to pay it, you get me off your back, because if you don't pay it off or you miss a payment, I will issue a warrant and you could sit up to 6 months in jail. It's very important that you figure out how to pay. And that's why I'm giving you a little bit of time and making it only $25 a month, okay?
All right, thank you, Your Honor.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. It says I need your fingerprints. Were you arrested?
No.
Okay, so I need your fingerprints. I need fingerprints with each and every open file, okay?
Okay.
So what you're gonna need to do after today, or after right now, is come up here to Amy, our clerk, get a piece of paper. When you're done, go to the outside of the building, go all the way to the back to the jail day reporting, okay?
Okay,
And then give them the paper, say, I need to give my fingerprints, you give your fingerprints, and then you're free to go.
Okay.
I also do have to order your DNA. They can take care of that too. If they don't have it, they'll swab you. If they do, then they'll just say, we don't need it. You have the right to request your DNA be expunged from the system, the CODIS system, if you know what that is, through a written letter to the Department of Justice, not to this court, not to me, to the Wisconsin Department of Justice. It's easy to do. You can Google it, just throw in some of those words and it'll pull up instructions of how to do
Okay.
it, okay? I think that's it. Good luck to you, and I will be praying and sending good thoughts and wishes.
thank you.
Thank you. We are adjourned. Had to wake it back up. Mr. Swenson?
So take this with you around to that day reporting lobby.
Okay.
And they'll do check for prints and DNA, and this is a map. So our main entrance is here. Go through that parking
Has
lot,
he
down the street,
sat 48
in the next
hours?
little parking lot, and they've got a
No.
buzzer at that door.
Okay, so he's gonna wanna do that. Before I proceed, I just want to make sure that you do understand that once I take your plea, and if you're found guilty, you have to report immediately to jail to sit 48 hours. Is today a good day to do that?
Yes, I already talked to Tessa about that.
Excellent, okay,
She had on the schedule. Yeah, she had on the schedule for the release on
excellent.
Friday.
We will go on the record in the matter 25 CT 51, State of Wisconsin versus Matthew Swenson. The state appears through District Attorney Kevin Schmidt in person. Mr. Swenson appears in person with his counsel, Bruce Anderson. We're set here today in this matter for a plea and sentencing hearing. Mr. Anderson, can you please state the agreement on the record?
Actually, I didn't bring my computer in today.
On the plea questionnaire, it just says to be determined.
That's because I didn't have my computer with me.
Okay, so would it be the IDIP guidelines for, are you sticking at the BAC 0.323, or is it amended as a part of the agreement to a lower amount?
Well, that's where Tessa spoke with Mr. Swenson, and I realize it's not her call. But she had quoted to Mr. Swenson
Oh, to Mr. Swenson.
a 45-day jail term, which falls in the guidelines for 0.15 through 0.169.
0.199, actually.
Pardon me?
It's 0.15 to 0.199.
I must have picked up an old guidelines then.
Could have the old guidelines. I'm looking at the new ones.
Oh, I got this out of the bin outside.
They might, I don't know, maybe I have the old one. I don't think so. Nope, because my old one says old, but can you hand me, oh, yeah, can you hand me one from over there? Because I'm out. Or we're out
So
here.
where are you?
Someone took my last one. so-
What's that?
This is, I have mine laminated, so I can have it, and this is what I have old and I have new. Oh, wait, from September 2025? No, this is the new one. Yeah. Can I see that one, please? Thank you. We're off the record, sorry. Yeah, these look very old. Oh, no, this says 0.99199. You said 0.169.
There's a newer one.
That's the last one I have. Let me see that.
There's a May 24 one that's distributing too.
Oh, here's the most recent one I have saved. Yeah, I don't have any up here, and I don't have that. 0.19, so
Is there in the 0.15 to 0.169? And then another one right after that.
That's what yours is saying. Must have redid it and I don't have the new one, so I'm gonna have to get a new one. That's fine. I have this now, so that looks like that. Just looks weird with the printing. Yeah, why do I have that one? Yeah, I don't, that's the only one I have. It's the very old one, because we have to go, sometimes when they get old, you have to go back to the old dates sometimes and things. Yep, I have that now. All right, I'll just have Tessa make me a new one, laminated new one. All right, back on the record, same appearances as previously noted. All right, so it's a 0.15 to 0.169, and is that the agreement, Mr. Schmidt?
No, I did it at the IDIP guideline. I don't know why Tessa said something different.
So, Mr. Anderson, do you want to speak with Mr. Schmidt
Well,
briefly off the record? Because I know Tessa doesn't have authority. She's not a lawyer. She just does the things.
Right.
But coming in here and then having to enter a plea and be sentenced and hearing that it could be a different sentence, I don't want to have any issues. She can't, off the record. Can you get me a laminated new one? Because I'm guessing Tessa's not here anymore. That's probably why she didn't give me a laminated new one, because she hasn't been here for a year. In here.
Kathy or
Yeah,
Kim.
I think that's what she, yeah, I think that's what she did. is she
Yeah.
was there. But
I don't know,
maybe
maybe
that's
she
why I
just
don't
missaid
have
it,
a
but
laminated one, because she didn't want to give it to me. So if you could
Give you the 65, see what's your discretion. So I think we just
Or May
basically
of
argue.
2025.
May of 2024, I have this is the one that I have, the last one that I was provided that said, yeah, that's very old, very old. That's like, ooh.
Yeah.
I think the reason it was revised in May of 24 is that's when the district guidelines changed too.
Yeah, that's what I just was
Yeah,
looking.
you're out, I'm out. I think Mr. Schmidt is out. I think we need more brochures too.
Yep.
All right. Mr. Anderson, thank you for bringing that to my attention. It's been a little bit harder with communication because Tess has been at home working all the time. And so usually she's the one that gives me all those things. So back on the record, same appearances as previously noted. Mr. Anderson, were you able to speak with Mr. Swenson?
I have, he understands that any time is going to be at the court's discretion, as well as any other portion of the penalty. And he is prepared to go forward today, knowing that.
All right, I have a question before we even proceed with plea and sentencing. If the court orders a fine of, let's just say, $1,911 plus a $10 blood draw, would you be able to pay that all?
Yes.
Okay,
Right away.
all right.
Yes. I take cards, right.
And there's, could be 75 hours or 100, depending, of community service. How do you intend to take care of that? Are you gonna do community service, or do you want to convert it to additional jail days? And that would be,
I spoke with, oh, want to
Go
go?
ahead. No, go
Okay.
ahead.
you go ahead.
Spoke with Teth about that. Obviously I did the 8 hours I had to do for the IDIP program. Obviously,
That doesn't count for the 75.
No, okay.
or 100.
yep, all right. And we talked about that, and being the president, I'm president of our snowmobile club and do countless hours of that kind of community service all the time, year round. And I know it doesn't go towards this, but I mean, I do quite a bit of it. And like I run the meat raffles for the Webster High School athletics program, help do that once a month for them. So I mean, I'm always doing community stuff for the thing, is what I talked about with Tessa.
All right, so
And Oh, I'm sorry.
You do a lot of community service in other ways, and it could be for clubs or by yourself. And that could come into an argument with the court as it relates to all of the sentencing. And it could be accepted perhaps, but with this, if you do convert it, it would be 10 extra days on the monitor. So an extra $250.
Yep.
Mr. Swenson has indicated he wants to pay the $250.
Okay, all right. Okay, so now
'Cause I
that we
paid-
have that settled and everything's going, we have an OWI third here. And I have your plea questionnaire and waiver of rights form along with the addendum to the plea. Did your attorney go over this document with you thoroughly?
Yes,
And he went over it essentially, basically word for word?
yes,
And did you sign this document?
yes,
You're pleading guilty to an OWI third offense. You are 47 years old. You have 12 years of schooling. You can read, write, and you understand the English language. You are currently not receiving treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or other medications in the last 24 hours. Is that all correct?
correct.
Did your attorney go over with you what the state would have to prove, as well as the minimums and the maximum possible penalties you face?
Yes,
Do you understand that because there are allegations of committing a crime, you are entitled to constitutional rights?
yes,
You understand that those rights are on the plea questionnaire? And did your attorney thoroughly go over those rights with you?
yes,
Do you need me to go over those rights with you in any more detail?
no,
You fully understand them?
yes,
And do you understand that by pleading guilty, you're waiving and giving up those rights?
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that as to count one, operating a motor vehicle while under the influence, third offense, that the state would have to prove on or around September 14, 2025 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, and this would be your third countable offense. Do you understand what the state would have to prove?
yes,
Do you understand the minimum possible penalty could be a fine of not less than $600, but no more than $2,000, and imprisonment of not less than 45 days, but no more than 1 year in the county jail? Do you understand that?
yes,
Do you also understand the court shall order an AODA, OWI assessment and driver safety plan and follow through?
yes,
You also understand that the court shall order your license be revoked for not less than 2 years, but no more than 3 years. Do you understand that?
yes,
Do you also understand that the court must also order an ignition interlock device to be placed on your vehicle during the revocation period?
yes,
Do you understand that there is an agreement that's been reached and it's been recited on the record? But do you understand I don't have to follow that agreement?
yes,
Simply said, I can sentence you to anything that I find to be appropriate under the circumstances, even if it's the maximum possible penalty.
yes,
Do you still wish to proceed and enter a guilty plea?
yes,
Did you go over that criminal complaint with your attorney?
yes,
In particular, did you go over the probable cause section?
yes,
And that's that part that basically says what happened and why you were charged with the crime. You remember that?
yes,
For the most part, are those facts accurate?
yes,
Are you admitting here today you in fact did operate a motor vehicle while under the influence?
yes,
And this, are you admitting here today, this would be your third conviction for operating a motor vehicle while under the influence?
yes,
Mr. Anderson, may the court use the probable cause section of the criminal complaint and the statements made by your client to find a factual basis?
Yes, Judge.
Has anyone made any threats or any promises to you for you to plead guilty today?
no,
Are you pleading guilty freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily?
yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
yes,
Has he looked at this matter thoroughly?
yes,
Has he discussed the evidence and discovery with you?
yes,
Has he discussed whether or not you have any legal defenses or a lack of defenses? Like, did he say, oh, it looks here like I think if we argue to the jury, we can do this? and
no,
this is
no,
Okay, so you don't, he talked to you about those?
Yep.
And do you understand, well, he talked to you about any defenses or lack of defenses. Are you satisfied with his services?
Yes,
You have any questions for the court or your attorney before I proceed?
no,
Then as to count one, operating a motor vehicle while under the influence, third offense, how do you wish to plead?
guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. The court will find a factual basis to accept your plea of guilt and that you understand the constitutional rights you're giving up here today. The judgment of conviction will be entered. Argument and sentencing recommendation, Mr. Schmidt.
Judge, we have these IDIP guidelines because it incentivizes people to do the programming beforehand that we believe makes them safer drivers in the future. It still has a punishment component in that it's very expensive. It results in a revocation of their license of some degree. And because it does have a jail component, even if that jail component for most of it's going to be on electronic monitor. He will still go to jail. He will still have that 48 hours that the legislature demands. But I think especially when we've had these days where we have a court with tons of OAR hearings where we see all the people who didn't do the driver safety plans, we see how beneficial for the community this sort of diversion or post-charging diversion really is. So I ask the court to follow the recommendation and give the defendant the benefit of the IDIP program. Thank you.
Thank you. Mr. Anderson.
Judge, Mr. Swenson got into the IDIP program relatively promptly. He completed it. And as I have no reason to doubt his discussions with Ms. Anderson, and of course, realizing she's not the one who makes the ultimate decisions. Mr. Swenson operates Sweeney's Bar and Grill in rural Webster. As he has said here, he didn't do any more than the required community service that had to be done. However, he is prepared to pay the extra fee for not getting community service. Although, as he's told the court here today, he, as the nature of his business, holds, shall I call them, charity raffles, where the profits from the raffles, if you will, go to, he mentioned the school district. He also made reference to the fact that he is president of the local snowmobile club and volunteers his time year-round for the various things they need to do to keep the trails accessible for when the snow comes, if it comes. But he also would need to make sure that the property owners are up to date with the easement grants that they may have given or seeking additional easement grants for any that they need to replace. That's an element of community service. He's not asking that that be counted, but I think what he's trying to make a point of is he's an active member of the Webster community and will continue that regardless of what the court may order here. If he chooses to do some other form of community service, he can work that out with Ms. Anderson after today even. On the night of his arrest, he was arrested in the evening and he did spend overnight before he got released after midnight. So that doesn't meet the 48-hour requirement, but it is where he would get 2 days of credit. He also had his operating privileges suspended by the Department of Transportation. And that was for a 6-month administrative suspension. So he will get credit for that time. And what I'm recommending, and it's a little bit, it's over minimums. we are requesting that the court impose 45 days of jail. That's only 10 days less than the maximum. He's going to pay his fine in full as soon as we leave court here today. The revocation can be for 24 months. He will get the 6 months credit. What I am hoping the court will fashion would be IID credit, where he won't have to have the ignition interlock device after he may have his regular license back. And the court did say he would have to have the IID during his period of revocation earlier. And I would like the court to consider a 1 year or 18 months.
I don't think I can do that, quite honestly. I'm pulling up the statute right now. I don't think I can do that.
It's interesting. The IID is being ordered for as little as 1 year in many cases.
Not in my court, and I follow the law,
I understand that.
I guess, except
And
guidelines, but
it may be an issue that I may have to take up with the DOT because he's going to get credit for the 6 months administratively. That is state law also. So may end up having to have the IID for the additional 6 months when he's back to his regular license then.
yeah, I'm seeing that there's no provision in the statute that would allow me to reduce the length of an order for an ignition interlock device lower than the mandatory minimum for any reason.
I understand. And certainly you follow the law on that, and it's pretty clear that is what it says. And I don't know if it's just creative judging in other places or not, but
Well, you can do what you can do until the Court of Appeals tells you can't.
right, that's what.
But I really do try to follow the law.
So anyway, we'd like to see a fine less than the 3175. We'd like the 1911, 45 days, 24 months IID and revocation, and the 75 hours of community service or payment or some combination thereof. 2 days credit plus the 6 months administrative.
All right, thank you. Mr. Swenson, anything you want to add, you want to state here today?
No, I know I screwed up. I've learned from there, and it was like I say, just a bad evening. They're my family, and I'm raising 2 young girls, and it's changed, and we've have erased that night from my life, and I've been doing very well and being a good father and a good husband.
Mr. Swenson, I'm very glad to hear that. I do not want to see you in this court or any other court for a 4th offense, because then it strips your driving forever.
Yes, I know.
Except the caveat of after 10 years, you can try and petition, but it's very hard.
I've learned that talking with my counselor through the Aurora, explaining all that, and she's which I've completed, and that really helped me a lot talking to her. So
And I'm going to tell you, and I know you understand this. I don't understand this personally, but my aunt owns a bar. She still owns it, actually. It's a different life. You are around alcohol 24/7, because let's face it, a bar really is kind of 24/7.
Yeah.
Even though you're closed some of the time. That's a big trigger for people to work and not drink if you have a substance abuse issue. Only you can determine to what extent alcohol controls your life. And if you're going to take control and start controlling your life instead of letting the alcohol do it. And I know I don't have to tell you, but I am going to tell you, because I do tell at least some people when I remember to say, the issue is not your drinking or your drinking in excess. 0.323, OMG, that's high. But I mean, my mom was a nurse, she saw higher, 0.5. So it's crazy that what the body can tolerate and build its tolerance up to. But But the issue is not you drinking or you drinking to whatever excess you want to drink. The issue here and the problem that you have at least 3 times now is getting in that car and driving. It's your life, you make the choices, but then you have to suffer the ramification of those choices. I hear that you are a good community man, good father. You're trying to run a business. You're trying to be there and help the residents of this county in multiple ways. And I get that and I understand that. We need more people, younger people of this age, not the 70-year-olds, because that's dying out. We need more
Yes.
younger people to be involved in these types of events, because otherwise they're going to die and then we're not going to have anybody doing them, such as how the Lions Club and the Lioness Clubs are kind of,
Yes.
they're suffering.
And I'm the youngest person in our Snowville club, so I know.
I know, and they suffer, and it's an issue because, I mean, I would love to do some of those programs. I can't, I just don't have the time. But I'm glad that you do. OWIs are very, very serious. I don't think I have to tell you, but I think we had a case where somebody left Sweeney's. I think a couple people did, and a kid got ran over twice by 2 cars, got hit by 1 car, then got hit by another car. Luckily, that wasn't you who has been in something that you didn't cause an injury or something to somebody else, or you didn't die, because you have 2 little beautiful baby girls that need their father. They need their father to be present with them and sober, and to step away from the bar sometimes.
Yes.
Because the bar, it really is your life. I know that. You're doing good things. You did the IDIP program, which is a lot, and you're getting your life together as it relates to the alcohol and that substance abuse issue. I don't think the community is at risk or at harm. You've learned a lot in the program, and hopefully, upon all hopes, you are going to install what you've learned into your life and continue that forever. Again, I don't want to see you get an OWI 4.
Oh.
What the court is going to do is, I mean, I can't guarantee or say that Miss Anderson told you a lower amount of time, and and Mr. Anderson knows that she's not a lawyer.
Yep.
She can't tell you what the sentence is going to be. But that's, if she did do that, then that's an issue for me to talk to her as her superior about that. In looking at all of the facts together and taking into account all of the information that's been provided to this court, what I am going to do is I will sentence you to 45 days in jail plus 10 days. So a total of 55 days. And I'm doing the lower guidelines simply because you are a community member that does a lot for our county and our community. And I believe that, I mean, you're going to sit 55 days anyway. You're just not going to have that community service requirement, but you are doing community service, not every day, but a lot of days. So that's why I am going to do the lower bracket. So it's $1,911 plus a $10 blood draw fee. You're going to pay that today, hopefully. Otherwise, I'm going to say you have 20 days to pay.
Okay.
Okay. I'm going to order 24 months of ignition interlock device and 24 months of revocation of your driver's license. I'm going to give you credit for any administrative suspension you've already received. And I'm going to state on the judgment of conviction in my decision here that if the Department of Transportation, the DMV, were to say that because of that credit, you don't need to have the ignition interlock device for a full 24 months. As long as I have proof of that, I'm okay with doing that, but they're the ones who essentially control that aspect. The law tells me I shall order 2 years at minimum. So it's 2 years ignition interlock device, 2 years revocation of driver's license with that credit. I am going to tell you though, I have never denied anyone, not anyone, when they apply for 50% cost for the ignition interlock device. So if you want to do that, you would see Amy, who is our traffic guru, and she can explain that or give you the form. Okay?
Okay.
Because to me, I don't care, well, unless you're a millionaire, I guess, but I don't care how much you make. I just want people to get that on, follow the law, do what they need to do, and get over that and be done. I have to order that you sit 48 consecutive hours, and it's an immediate report. You did the IDIP program, so I will give you the option to serve the remaining time on electronic monitor, which does monitor your skin and your
Yep.
sweat. So it'll detect if there's any amount of alcohol in your system.
Yeah, that's fine.
Plus, if you don't get gasoline or rubbing alcohol or mouthwash or probably cologne near it, because it will go off and give a false positive. I'm going to tell you right now, I don't listen to people's excuses of false positives. If it alerts that there's that it detected alcohol, you will be told you're immediately revoked and you must go sit the rest of the time in jail. No good time, no Huber. All right. Well, on the monitor, 2 days jail credit.
Yes.
And while on the monitor, absolute sobriety, no alcohol.
Yeah, that's fine.
You can go to work. You can go to church. You can go to the grocery store 1 time a week. Tessa will go over the policies, the procedures, and the limitations there. You can't do, I mean, community service, because you're doing it, that may be something that will be approved. You have to talk to Ms. Anderson, and then she'll send me a request, and I'll decide if that's appropriate. But you can't go to somebody's pool party.
Yes.
You must only throw your own pool party. People can come see you. You can't go to them. Do you understand?
Yes.
Anything else I'm missing besides the last words I have to state on the record as it relates to the monitor, et cetera?
Well, I'm sure he can work this out with Miss Anderson. He's a bartender. He works at his own bar and grill,
That's Huber, that's fine.
but he may get alcohol on him that spills or whatever,
No, that's his problem.
cleaning up a table. So
You just better be
There,
careful.
that's, well, I was going to ask that question also. I mean,
I mean, and
Doesn't
if you
happen.
want- If you want to tape a bag, like if you have a cast and tape it over there while you're cleaning up, then that's what you got to do.
okay,
Because if it registers, I understand that you do work in a bar and grill and you do those things. And I do understand alcohol spills, but do you see how I can't?
yes, no, I
can't
understand.
trust that
That's-
That's it.
Yeah.
I've been told so many things, and that's why it's like, nope, it is what it is. You'll
No,
be revoked.
I
okay?
understand.
And then Judge, one more thing about the extra 10 days, that's for the community service. And what does he have to pay for that if he doesn't want the extra 10?
Oh, it would be $250.
Right.
And that would be
'Cause I paid-
paid to Miss Anderson, and you have to prepay 30 days in advance for
I
the
did.
monitor. Okay?
Yeah, I did. That's
It's done. Yep.
Okay. So that would be an extra $250. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, the court will enter a civil judgment against you. I will also issue a warrant. You could sit up to 6 months in jail. I need your DNA. You're gonna have to provide that to the jail. They'll get it when they book you in. You have the right to request it be expunged from the system through a written letter to the Department of Justice, not to me, but to the Wisconsin Department of Justice. It's easy to do. If you want to do it, you can Google it or ask Mr. Anderson. He can show you how to do it. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Anderson.
I believe that covers everything, Judge.
All right, immediate report. What you can do is go to the clerk if you're going to pay your stuff, do your thing, talk to your attorney. But then once you're done, immediately go to the jail, get booked in, sit your 48 consecutive, and then you can be hooked up with the monitor, okay? Ms. Sangate?
Then jail, like, go at the front and walk all the way around.
Yes.
You come up here, I have your minutes.
Want to take this up too?
So this is our main door, go around, and they've got a buzzing door over there. It's called Jill Day Reporting Lobby. Oh, nope.
Oh, that's. turn that in.
That one.
I'll read it out loud. We will go on the record in the matter 25 CM10, State of Wisconsin versus Veronica Sangate. This date appears through District Attorney Kevin Schmidt in person. Ms. Sangate appears in person. Her attorney appears by video conferencing with approval of the court and with Ms. Sangate. Before we begin, Ms. Sangate, your attorney is appearing over there on your left-hand side on that big monitor. Do you see him?
Yes, I do.
Do you understand that you have the right to say, you know what, Judge, I want him to be here in person so I can have the plea in person?
Yes, I do.
Also, I'm calling 25 CF 169. So, but you're okay with him appearing by video conferencing?
I'm fine with that.
Okay. If you have any questions or concerns and you need to speak with him, let me know. And then I can send you outside to either give him a telephone call or send you to our Zoom room and put you in a confidential breakout session, okay?
Okay.
All right, so the parties have reached an agreement, but before they've reached before I'm gonna have Mr. Keen put it on the record, the court was just provided a character letter that has not been able to be scanned. So I'm going to briefly read that so Mr. Keen and Mr. Schmidt can be aware of what it says. Honorable Judge Melissa Mogan, here is a character letter on behalf of Veronica Sangate. My name is Susan Miner. I've known Veronica for over 20 years. During that time, I have consistently seen her demonstrate deep love, patience, and dedications to her family. Since the passing of Veronica's daughter, is it Evie or Evie?
Evie.
Evie.
Yep.
My daughter's Evie, and that's how you spell it too.
Oh,
So
okay.
it's Evie's mother, Veronica, has stepped up to provide stability, emotional support, and a nurturing environment for Evie during an incredibly difficult time. Some of my strongest memories involve seeing Veronica and her grandmother, who also passed now, and Evie spending time together fishing. They were always laughing, talking, and enjoying each other's company. It was clear how much joy those moments brought them all, and how committed Veronica has always been to making Evie feel loved and supported. On a more personal note, when I lost my own mother, I looked to Veronica for advice. She offered kindness, understanding, and guidance through the most painful time of my life. She showed me the same compassion she shows her own family every day. From everything I've witnessed, Veronica is a devoted grandmother and a genuinely caring, responsible person. She provides a loving, stable environment for Evie, and I trust her judgment and integrity without hesitation. Thank you for your time. Respectfully, Sue Miner. Dated November 14th, 2025.
That's probably when I first was going through this.
Well, it's dated even before the first charge of November 18, 2025.
Yeah.
I don't get it. I don't know.
Well, she just wrote it on my behalf.
I don't know, but that's what it
Yeah.
says.
Your Honor, if I think I can help. I believe it was part of the criminal cases, but I believe there was also a placement case because of
Mhm.
items
That's what it was
found.
for.
I think it may have been related to that, Your Honor.
Mhm.
Okay,
Yeah.
that sounds good. Either way, I read it. I read the
Okay.
date. It was just confusing.
Right,
So,
sorry.
an agreement has been reached. Mr. Keen, can you please recite the agreement for the record?
Yes, Your Honor, and I don't know if Ms. Sangate has signed the paperwork and provided it to the court itself, the plea agreement and the notice of rights. I went over that over the phone with her for around half an hour this morning, word for word. I don't know if she's had a chance to bring it up so the court has it,
Yes, I-
but okay, so the agreement calls for the in the felony, the possession of methamphetamine charge to be amended to the misdemeanor possession of amphetamine charge, all other counts to be dismissed and read in for DNA costs, 2 years of probation. And I know that I've sent Attorney Schmidt on July 8th the proof that Ms. Sangate had done the counseling and the screening for substance use and abuse. So I believe that Ms. Sangate has complied with the requirements of the offer. If DA Schmidt differs in that, then I don't want to speak for him.
Mr. Schmidt, please respond to Mr. Keen if something's different, and also provide me a basis as to why this is in the public interest.
It's in the public, I do find it acceptable. It's in the public interest when people go out and do treatment things on their own. It's actually better than when we order probation and expect them to do it on probation, because then they have more buy-in, they have more initiative, they're doing it of their own volition. Whenever we do treatment of anything, not just substance abuse, but mental health, which is what's involved here as well, you get better results when the patient is involved in the creation of their own plan. So for that reason, I think it's appropriate here.
And the child issue has been addressed elsewhere?
I think the child issue, the cause of it is the mental health and the substance abuse. So I view this as dealing with that. This is
Okay.
not something where I think, I don't know, parenting classes, these issues came from substance abuse and mental health.
All right, okay, formal motion to
Your
amend
Your Honor?
count.
Oh, sorry.
Yes,
Sorry, I wasn't on the child case, but I believe that the child was placed in a different home. So I think that was one of the other ways of addressing it. If I'm wrong, I would ask Ms. Sangate or DA Schmidt to correct me.
No, that's right.
okay, thank you. But technically, just, I can't mention anything about any child case because it's confidential, so you can say all you want. So there you go. So formal motion to amend count 1, possession of methamphetamine, to a misdemeanor possession of amphetamine.
So made.
Granted. I have in front of me a plea questionnaire waiver of rights form, Ms. Sangate. This
Mhm.
is the document your attorney said he went over with you word for word. Is that true?
That's true.
And do you have a copy in front of you?
I do.
Okay. And did you sign that second page?
Yes, I have.
You're pleading guilty to 1 count of possession of amphetamine. You're 59 years old. Do you have a high school diploma?
No, I don't.
Do you have an HSED or anything?
No, but I tried to get one.
And you
And
can read, write, you understand the English language?
yes, I can.
Did your attorney go over with you the charges that you face as well as the maximum penalties?
Yes, he has.
And are you currently receiving mental illness or treatment for a mental illness or disorder outside of AODA?
No,
Have you had any alcohol, medications, or drugs within the last 24 hours?
no.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on the first page of that plea questionnaire right there in front of you. Each of the boxes is checked. That tells me that your attorney went over those rights with you and that you understand them. Is that correct?
That's correct.
Do you need me to go over those rights with you in any more detail?
No, no thanks.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, I do.
Do you understand that here the state would have to prove on or around November 18, 2025, you possessed a substance. The substance was a controlled substance in an amphetamine classification, and you knew or believed that substance was a controlled substance in an amphetamine classification. Do you understand what the state would have to prove?
Yes,
Do you understand the maximum possible penalty could be a fine of up to $5,000 or imprisonment of up to 1 year in the county jail, or both?
yes, I do.
Do you understand that there is an agreement that's been reached for the court a recommendation for the court to place you on probation? Do you understand I'm not bound to follow that?
Yes, I do understand that.
I could sentence you all the way up to the maximum possible penalty if I thought it was warranted.
Yes,
Do you still wish to proceed and enter a guilty plea?
yes, I do.
Did you go over that criminal complaint with your attorney, in particular, the section that's called the probable cause section, where it basically says what happened that day and why you were charged with crimes?
Yeah, yeah,
For the most part, are those facts accurate?
yeah,
Are you admitting here today you in fact did possess the substance in an amphetamine classification?
yes,
Are you pleading guilty because you are guilty?
yes,
Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty today?
no,
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
yes,
and voluntarily.
yes,
Has your attorney represented you competently?
yes.
Has he
yes,
answered all of your questions?
Yes,
Has he looked at these matters thoroughly?
yes,
Has he discussed with you a potential for any legal defenses or a lack of defenses?
yes,
Has he discussed the evidence and discovery with you?
yes,
Are you waiving a jury trial and entering a plea because it is your choice?
yes,
Are you satisfied with your attorney's services?
yes, I am.
Any questions for the court or your attorney before I proceed?
No, but I would like to.
You'll get to
speak.
say something.
Okay,
Okay. As to count one, amended count possession of amphetamine, a U misdemeanor, how do you wish to plead?
guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count one, counts 2 through 4, and the other matter will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. This is a drug case. Drugs, when you get addicted to them and start using them, affect all aspects of your life, even if you have insight on it or not. So to that end, what we've accomplished today with this plea agreement is the best way of dealing with what the core issue is, which is we really want to see people voluntarily, without DOC over their shoulder, without the court ordering it, doing these things beforehand. And I think that goes a long way here and why the court should follow the agreement. Thank you.
Thank you. Mr. Keen.
Yes, Your Honor. I know we're looking at the sentencing factors. You look at probation first, unless the jail is necessary to avoid undermining the seriousness of the offense. I think the only aggravating thing in this case was the presence of a minor child in the home. That was remedied through a different case. So I think the court should look at. However, I do want to note a couple things, and then Ms. Sangate will discuss them in her right of allocution. Is usually when I've had these cases where a client, does the treatment ahead of time and gets the benefit of an amendment to a misdemeanor to avoid the collateral consequences of a felony. Usually the client has only, and again, people are in different places. Usually a client to get that has taken care of things for their own needs. However, Ms. Sangate, and she'll talk about that in her own words, because they're better than anything I would say. She's actually also worked to help others as a support for the mental health issues and other things that led her to that path. And she has also regained employment. And I know that's useful because, when you're active in a community, it makes you less likely to relapse. And also, frankly, I know we had some communication issues. That's why I had to email the paperwork to the clerk and then have her sign it. It provides her, more regaining employment provides some more financial freedom, so that will probably help with mood and other things. And also, the more integrated you are in the community, the less likely you are to relapse and fall back into those things. So I think the court should accept the agreement, not just because it's a fairly standard practice, but because Ms. Sangate has actually gone above and beyond what's required for it. And she's actually, worked to support others during this time as a means of therapy for herself as well. So, and would leave that to Ms. Sangate to explain to the court. Thank you, Your Honor.
Thank you. Anything you want to say?
Yes, I would, Your Honor.
You have the floor.
Okay. Can I just say?
Yes.
Okay. Your Honor, I'd just like to say that, I know you don't really know me, but from what you read in my, my criminal record, but, people do change, and it's one thing to say that I have done a lot in my lifetime and that wasn't right, but I have come to terms with myself that I had to pay back, so I do a lot of volunteering and that's with my community and outside my community sometimes. But I got behind and I went and with my granddaughter, I had my granddaughter. I did a lot and I got overwhelmed and that's how I fell back. And I mean, I wasn't looking at myself, taking care of myself. And so when I volunteered, I just made other people more important, and that's my downfall because I can't say no sometimes and it's hard for me. When I should, just, well, anyway, I took a look at myself and after all this happened, I figured out that I had to do for myself for once. And I went and got into counseling and I really am getting a lot from it. And it has to do with grief because of the fact that AODA and grief go together for me. And I didn't let go of a lot of things that I should have and it got in the way. So right now I'm dealing with that and I'm getting, the counseling is really doing good for me. So I'd like to just say that I did get employment and one of my old bosses where I worked called me and asked me if I could, work again for her. And I took the job. It's a on-call job and it's housekeeping for a hotel and it's great work. And so with that, I'm just saying, oh, and I got my granddaughter for the summer. So that's really good. I'm really happy about that. But things are going a little better today and I just would like to say that, I'm doing a lot better.
Okay, well, I'm so glad to hear that, Ms. Sangate.
Mhm.
And I do believe people can change.
Mhm.
I do. And you're right. I don't know you very well. You're not here,
Yeah.
which I love and enjoy you not being here, at least in that seat. I'm very glad to hear of all the progress and the improvements that you're making in your life, because it's very important, not only for you, but for your granddaughter. She needs you very
Mhm.
much. She needs you to be present. She needs you to be focused and she needs you to be sober.
Yes.
And so I'm glad to hear that you're doing those things. I want to know, and I want you to promise you're going to say no a lot more. You
Yes.
do not have to do things. You do not have to overextend yourself. You do not have to empty your cup to do things for others,
Right.
because that was the issue. Your cup was empty. You weren't refilling it. You weren't taking the time for you. You weren't doing things to make you feel better. And then you relapsed to methamphetamine.
Yeah.
You look like a beautiful, intelligent lady.
Thank you.
I don't understand it. I mean, I see it every day, but I just don't understand the pull to methamphetamine.
Yeah, it's hard.
And so I can say I understand it and I can feel it, but I don't actually personally know. But I'm glad that you are being strong. I'm glad that you are taking control of your life. I don't think the community is going to be harmed with putting you on probation because you're doing the things that we would require you to do. And you did them without being forced and told to do them. So probation is appropriate. What I'm going to do is I'm just going to do 1 year of probation. I think that you can get everything situated and figured out in a year. So I think that's great. Sometimes probation, having it too long, can actually make things worse because if you've already gotten your life under control and you still have probation for another year, then, that can actually hinder you or be another hiccup. Because if you're going to relapse or you're going to commit a crime again, chances are most likely you're going to do it within a year. And then you will either be revoked or and get additional charges or all of those things. So 1 year of probation, but what I'm going to do is I'm going to do an imposed but stayed sentence. That means that if you are revoked off of probation, you don't come to me and argue and say, you know, please sentence me to this or please sentence me to that. You will immediately go serve your time, okay?
Okay,
And then so you won't be questioning, okay, how long am I gonna get? What am I gonna do?
yeah,
You will know exactly what your sentence would be if you're revoked.
okay,
So hopefully that's enough of a stick over your head to go, I'm not going to mess around. I'm going to do what I need to do, control my own life. All right. So what I'm going to do is I'm going to, in a case like this, it's not the maximum possible penalty matter. This never would have been a prison case anyway. It's not even a year in jail type of case. So in looking at all the facts and everything that I have in black and white and hearing the arguments from each of the sides, what I'm going to do is I'm going to sentence you to 4 months of jail. Okay, 4 months of jail if you are revoked.
okay,
So you know what it's going to be.
right,
And so if you want to, if that doesn't scare you,
no,
then you're just going to do what you want to do. If it scares you enough to keep you straight, then, you know, if that's one more thing that's helping you to stay on that good path, then that's what it is. But at least you know what the punishment will be. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need your DNA. You're going to need to provide that to the jail.
okay,
You have the right to request it be expunged through a written letter to the Department of Justice, not to me, to the Department of Justice.
Okay.
Okay, it's easy to do. Google or ask Mr. Keene.
okay.
On probation, you have conditions that you're going to have to meet.
Mhm,
Absolute sobriety.
mhm,
No use or possession of any illegal drugs, substances, or paraphernalia.
right,
No bars, taverns, or liquor stores or casinos unless it's for employment purposes only. No establishments that have the primary purpose for the sale or service of alcohol.
Okay.
You can't go to a beer tent. You can't go, you know, places that are,
just stay away from it all.
stay away.
Okay, I can do that.
Regular testing. Trying to think of if there's anything else that I should order or think of a condition. Just follow the recommendations of your Department of Corrections agent and any programming that they see is necessary, okay?
Okay,
I'm proud of you. You look
Thank you.
great. You look like you're feeling great.
I am.
How long have you been sober?
Oh, I mean, I'd have to say by November, right after all this happened, I used once and it's, got to me, and that's why I stepped up and did what I had to do for myself, so it's been a while.
So it's been a while.
Yeah.
I'm going to give you a little hint
Mhm,
of information that I've learned,
mhm,
that when individuals know either the date of their
Yeah.
sobriety or, close to, and they can say from, March,
Yeah.
whatever,
Yeah,
then it gives them a more solid base.
yeah,
And they can say 183 days sober or November 14th, 2025. Because then they have that date to continue to look forward to,
right.
because one more year is a celebration.
It is.
Another year is a celebration, and it's just like a birthday or an anniversary.
Yeah.
It is. And so it's that important.
Yeah.
So that's just my
Yeah, I know.
thoughts to
We
you.
talked about that in counseling, so.
Well, that's good. I'm glad.
Yeah.
See, I'm that way, what I'm gonna do is I'm gonna assess $500 in fines and fees. You already have that paid. You're good to go. You don't have to worry about that. You do need to report to probation immediately,
Okay.
okay?
I can
And
do that.
so that means right when we're done, you go give your DNA and then you head right over to probation,
Okay,
all right?
all right.
I think I said 20 days to appeal. Am I missing anything?
No.
Mr.
Your
Keating?
Honor, just because I mentioned, because I'm going to inactive status on July 30th of my license. I informed Ms. Songate during our meeting earlier that if she wishes to appeal, on or after July 30th, instead of contacting me, because I wouldn't be able to file anything for, that she would need to contact the local public defender's office just to make sure her rights are protected.
All right, good to know. So you know that if you want to
Yeah.
appeal, then you just have to do that route, okay?
Okay,
All right.
Have you ever seen a judge show both compassion and accountability in the same courtroom? At first, this looked like just another OWI sentencing hearing. But as the facts came out, it became clear this case was about far more than one bad decision. The defendant admitted responsibility for driving under the influence for a third time. Instead of making excuses, he accepted guilt and explained that he had completed an alcohol treatment program, stayed involved in his community, and was working hard to rebuild his life. He even spoke about being a father and wanting to become a better example for his family. The judge acknowledged all of that. She praised his volunteer work, his commitment to change, and the progress he had made. But she also delivered a powerful reminder that personal growth doesn't erase the consequences of dangerous choices. She explained that the real problem wasn't simply drinking, it was choosing to get behind the wheel after drinking. The judge warned that a fourth OWI offense could permanently change his future and stressed that his children needed their father alive, sober, and present. When it came time for sentencing, the court balanced mercy with accountability. The defendant received 55 days in jail, a substantial fine, a 2-year driver's license revocation, and a 2-year ignition interlock requirement. The judge also made it clear that while serving electronic monitoring, even a positive alcohol reading could send him straight back to jail. The hearing ended with a message that resonated far beyond the courtroom. Everyone makes mistakes, but every choice carries consequences, and real change is proven through actions, not words. What do you think? Did the judge strike the right balance between compassion and punishment, or should the sentence have been even tougher? Let us know your opinion in the comments below. And if you enjoy real courtroom stories with important life lessons, don't forget to like, subscribe, and turn on notifications for more courtroom moments.